again, there's some instances where these people rent out the Airbnb specifically for the purposes of doing things they wouldn't do at their own home, i.e. creating a meth lab in the Airbnb, leave it, and that's the end of their involvement with that property. So these can be problematic. And again, I mentioned this earlier, they may have purchased this property with the specific intention of making money on it and not investing into the community. So, they pay their dues, they pay everything else, but they rent it out every day of every year. And part of the problem with these is a lot of these documents didn't contemplate this exact thing. Now, yeah, there may be provisions saying you have to provide a lease and things like that, but it's frankly hard to enforce because they may only be there for one night. And you would not necessarily know if that's a guest, if that's it can be difficult to enforce. And then when it is addressed in the documents, how much is an appropriate fine for doing this? You have to find the balance where it's not so excessive that a judge looks at it and says, that's ridiculous, I'm not going to ever award you that. But it also has to be enough where it penalizes them to the point that it deters the use. Because if you find $50 a month for short-term rental use, and that's all your documents allow, there's really no deterrence factor there for that owner, because they'll just pay the fine and keep doing it. And then additionally, the people present on the property, they can expose the association to liability for acts that they've done or that occur on the property. We don't always know who all these people are. They may have a big raging party that affects everyone, and it just becomes a headache to track all the different working parts down. Next slide. But wait, there's more. As if you hadn't heard enough about all the horror stories with Airbnb, VRBO, and just the simple rentals involving just the home, there's more, unfortunately, just like an infomercial. There's always something you didn't ask for. Next slide. Here's some other problematic short-term rentals, and I'll kind of go through them and explain as to how it could impact community associations. Has anyone heard of Swimply? It's an app where individuals can rent out the private use of their swimming pool. For an individual in a home, that may be fine. It may be simple. It comes with a slew of considerations, insurance, what happens when they're injured. But what happens when it's a condominium owner who has a community pool and they say, I'm going to rent this out to someone else? And there's a whole problem with that gets into deeper issues. But nonetheless, if you're not even aware of these apps, and I'm sure some of you have never heard of this before, it's not something the association or its manager is going to track. I hadn't heard about this until I went to a CLE about a year ago. You don't know about these things. Then there's Sniff Spot, an app where individuals can rent out their yard to dogs. And again, in a one-to-one level on a private home, it may not be problematic. Again, you still get the considerations of what if this dog bites someone? What if this dog creates damage? But imagine if it's now a dog that's being rented out to use common area of the association, and some issues occur with that. Again, this is an app that you may or may not be aware of, you may or may not be monitoring. And then we get into some of the other ones that may not be as problematic, but still something that associations may want to consider monitoring and or making rules pertaining to. Neighbor, an app where they can rent out unused spaces, garages, carports, sheds. That kind of goes with curb flip, which is individual parking spaces. And any manager association can tell you parking's an oft contested issue. And now you've got this other car appearing, and I'm sure there's rules that govern who can park there and what they need to park there. And now you've got a third party coming in from an app that you may not have been aware of, renting out the parking space. So it just becomes problematic because you're getting an element that the association is unfamiliar with, they may not be aware of. and they may not even be monitoring. And then we get into peer space. Maybe this one's a little less, but you could still see it in the regard where they rent out associations, common area for meetings or for a venue. Depending on how your association's set up, you may or may not have these kind of common areas or clubhouses that could be rented out in this capacity. Maybe more so for the Hollywood people here, set scouter. It's where individuals rent out the space for film or photography purposes, less likely to impact associations here, but you never know, especially if there's a more upscale association they want to feature in a film. You could have someone listing it on there trying to make some money off the film recording it. And then there's kind of like the dark web use of the underground sharing economy. Maternity hotels, and this is something I wasn't aware that even went on either. It's these hotels that house foreign nationals for the purpose of having their children born in America, so that they become American citizens. I'm not sure how commonplace this is or how often this is seen, but it's nonetheless, it's one of those concerns that if you see some comings and goings that you're concerned about, something worth keeping in the back of your head. Next slide. And with all these scary things I just talked about, there are ways to combat these short-term rentals. And the shortest answer is to amend your documents. Be proactive rather than reactive. If you start addressing these things after they start renting them out, they're going to naturally say you're targeting them, or you're only doing this because of XYZ. And to be proactive about it is the best way of handling these things, especially if you do have things like community pools. It's better to get ahead of these issues than dealing with them after the fact or after the incident has occurred that you've now been in litigation over for whatever reason. Typically it's done via declaration, bylaw, use restrictions. And it's creating new rules to specifically contemplate the short-term rental itself, the requirements. And one big point is also the marketability of it, to address that not only is it against the rules to use it as a short-term rental, it's also against the rules to list it as a short-term rental. Reason being is because you're going to have the Google lawyers that say, well, I didn't technically rent it. It's only available for rent. It's not technically a rental. It combats everything that they're going to throw at you when they, go on Google and how to combat association about the short-term rentals. Fines are always a good deterrence factor, but again, you need to figure out the right balance. $50 isn't going to be something that's likely enough to combat the use of short-term rentals. But again, if you're finding $10,000 a day for the short-term rentals, they're not likely to uphold that in a court case, or if it were to proceed further than that. It's just unconscionable if you were to charge that much for the use. And if there aren't any current issue or current provisions of the short-term rentals in your rules or your documents, using nuisance provisions against the owner for loud parties, unruly behavior, things of that nature, and to enforce those each and every time that something occurs, and not just selectively or in any kind of capacity with that. And then also, in this kind of a last resort, investigate what your municipal restrictions are on this. The municipality you're in may already have rules and licensing requirements for the short-term rentals that you could look to as far as enforcing them. But it's better to just have it in your documents and just make it simple. So as far as how to do that, and I'll give you over to Lydia, who will tell you how to amend your documents.
Awesome. Thank you, Sean. Go to the next slide. I'm not on mute. Okay, good. Thought I was for a second. All right. So before we get into the basics, I wanted to talk to you really quickly about the short-term rental, just kind of wrap it up from some of Sean's points. Coming up in our near future here in Milwaukee, we're going to have the Republican National Convention next year in July. And I don't know if you all remember, but a few years ago when the DNC, Democratic National Convention, was planned in Milwaukee, there's a lot of scuttlebutt about short-term rentals. And, you know, we have a lot of people coming into town that need places to stay. And some associations saw that as a big opportunity. Gosh, it's a great way for owners to rent out their unit and make money. Other associations saw it as a big problem and something that they wanted to make sure they could combat and make sure it didn't happen in their association. So depending on where you are and what the feeling is of your owners, I would encourage you as a group, now's the time to talk about it again, because if you're in the camp of we don't want short-term rentals in our association, then now's the time to make those document amendments to make sure that they are not allowed and you have ways to enforce so owners don't try to get around the rules. And on the flip side, if you're the association that would love to take advantage of it and allow your owners to profit a bit from it, again, think ahead, make sure you've got the security measures in place and also the right kind of rules to make sure that the behaviors of your guests during these short-term rentals don't turn into chaos for your association. So just stuff to keep in mind as we get into the next year here. But talking about our amending documents, the basics. So we'll start with kind of a 101. You've got different types of governing documents, and they all have differing types or ways to amend them. Declaration, of course, is the one that's recorded with the Register of Deeds. It requires at least 67% of your owners to agree in writing before you can amend the declaration. If your particular declaration calls for a larger percentage, then that's what you have to go with according to the law. And you also have to send a copy of any amendment to the declaration to all of those folks who said yes to their lenders. Law made it easier on us now. We no longer have to get written consent from the lenders, but we still have to do a special mailing by certified mail. Has to say certain things in the letter. All these little check boxes you have to do, but if you do them, all you need to do is mail it the right way, wait 60 days, and then you can go ahead and record your declaration amendment with a Register of Deeds and be all done. The plat, if you're going to amend your plat, that requires not just a lawyer, but also a surveyor, because you'll know that a plat is a survey map. So we need a surveyor involved to draw up any changes that need to be made there. But if you need to do voting on it, it'll be the same way that you would amend a declaration. So whatever your declaration says as far as percentage of owners vote that you need, that's what you need for a plat. And we'd also need the lenders to give their consent or at least not object within the 60-day period to these plat changes. And I'll mention, because I know not everybody on here is a condo owner or works with condos, for HOAs, subdivisions, it's kind of the wild, wild west. Your declaration and plat, the way you change them is going to be dictated entirely by the terms of that particular declaration or declaration of covenants. So you'll have to read it and look at the amendment section. It's kind of all across the board. Sometimes you need lender approval, sometimes you don't. Sometimes you need all the owners to sign the amendment, which requires notarized signatures, and that can be a big headache. So just make sure you pay close attention to what the declaration says for that particular association, and that will give you the roadmap to amend. Articles of incorporation, if your association is a corporation, you do need owner votes typically. Sometimes the articles will say that the board can amend it, but most of the time it's a majority or 2/3 of the owners. Bylaws, that's that document that talks about the governance of the association, how the board is elected, how you conduct your meetings, annual meetings, board meetings. And this one is easy because it's set by statute. It says that anybody that wants to amend their bylaws requires 67% affirmative vote of all of the unit owners to accomplish it. But as I say that, there is one exception, and that is if your association has been around since before August of 1978, and that's when your original bylaws were put in place. If your bylaws say the board can amend the bylaws, you are fine. The statute didn't kick in until after August of 1978. So if you haven't touched your bylaws since then and they still say that, hey, good for you. You might be able to amend your bylaws as a board. Finally, rules and regulations. Always check with your declaration or bylaws, because while most of the time rules and regs can be created and amended by the board, sometimes your declaration or bylaws may require an owner vote to approve those. So just pay attention to that to be sure. Next slide, please. Okay, so now we're going to get into these kinds of amendments that you want to make sure that you're having on your radar as an association now. The red light, the red flag, anything red that you can think of, my jacket, that you have to make sure that if you're seeing these things in your documents, there's something that you need to do right away. Next slide. So first of all, if you see anything in your documents that conflict with a current law or statute, that's something that you want to amend soon. Some examples: language that discriminates. The sneaky one that I see most often is discriminating on the basis of age or familial status. The key word is children. If you have anything in your documents that uses the word children or kids, be careful. Sure, you can certainly pass rules that protect children, but there's ways in the wording that we have to be very precise about so they don't look like the association is trying to target children, because that would be a different thing. So my rule of thumb is if you have a pool, for example, and you have the word children in your rules, pretty typical. We want to make sure that we're amending those rules so they make it clear that the rule is for safety purposes and not meant to keep children out of the pool. Flags. Can we restrict flags? Yes. Can you say that we cannot fly the US flag? No. There's laws to protect the US flag, the respectful display of the US flag. So only thing that you can really do as an association is restrict the size of the flag and location where it's placed. And so I would say be proactive about it. If you don't have any rules about flags and the size and location, then you don't have any rules. So really anybody could put the biggest US flag they could find, and it would be hard for you to tell them they cannot. So those are rules you want to be proactive about. Signs is kind of the same thing. I see a lot of documents that say we don't allow any signs to be shown outside of the unit. And that's not okay because there's a statute that says otherwise. Political signs of a certain type, so the ones that support or oppose a candidate that's up for the next election or a particular referendum, those are protected by law and you have to allow them. Again, you can restrict the size and location in your rules if you want to be proactive about it. But if your documents say no signs, just know that they are already conflicting with the state statutes and can cause some confusion and problems if we don't amend that. Satellite dishes and antenna. These are protected by the federal law. And I can't tell you how many condominium documents I've read where it just says no satellite dishes, or satellite dishes are okay if they're approved in advance by the board. Can't say that. Unfortunately, the federal law says you can't prohibit placement of satellite dishes and certain antenna within the unit and within the limited common area, which is typically like the patio or balcony deck attached to the unit where people are going to want to put their satellite dishes. So we can write rules about where they're placed to a certain extent. We can write rules about how they're put there and whose responsibility is to pay the cost of any damage, installing and removing. But the saying no satellite dishes is something that will get you in trouble and we want to remove from your documents and amend. Next slide. So back, or continuing on the red flag type amendments, if you see anything in your documents between the types of documents that conflict with each other, that's a problem. There's a hierarchy of documents in the law. The statutes make it real clear that your declaration is primary, and then it follows on down that list that you see right in front of you there. So if you have something in your rules that conflicts with the declaration would control, but you've got a rule then that's unenforceable, and folks might not know that, and that creates problems. If you have a rule that conflicts with something in your bylaws, that would be a problem. If you have something in your bylaws that conflicts with the declaration, I see a lot of bylaws and declarations that both describe maintenance and repair responsibilities for the owners in the association, and oftentimes they are not saying the same thing. So that again creates problems for enforcement and for the association. So if you see anything that's inconsistent in your documents, that's something we want to fix. I gave a couple of common examples here. Many declarations were written originally that say something really general about renting units, saying something like the declarant can rent however they want, but unit owners can rent their unit as long as the lease is at least 6 months long. Well, then if your declaration says that, we can't put anything in the bylaws or rules that tries to place a cap on rentals, because the declaration controls, and the declaration is already putting out the message that any unit can be rented. The restriction is just on the length of the lease. So that creates a problem of enforceability for the rental cap that you tried to put forth in your bylaws. So something to look out for. Another example, say your declaration says you can only park one car in the driveway overnight. And many owners were parking 2 cars. So the board just thought it prudent to make a rule that says 2 cars are okay. Well, it's really not, because your declaration still says the 1. So that's something you want to look out for and avoid. Next slide. Gosh, we have so many of these red flags. Okay, so provisions in your documents you don't enforce. This is a big one. So many associations just kind of go on their merry way, and there's certain things you don't enforce all the time, but we don't amend the documents to take it out. And that's an issue. And we'll get into why. Here's some examples. Say your declaration says you can't have enclosed patios, but the developer allowed a few people to have them, or boards in the past allowed them. But the declaration's not changed, you're not enforcing that provision, and that can bite you. Bylaws might say no dogs, but some owners do have dogs, and they're not emotional support animals or service animals. They're just dogs that happen to show up and nobody said anything about it. Rules. Your rules might say owners can't plant things around their patio, but some owners did plant flowers in the past and they looked really nice, so we didn't say anything about it. And you're not enforcing that rule. All those things really need to get addressed, and soon. Why? Because if you don't, it just makes it really impossible for the board to enforce the documents that you want to. If you're not enforcing everything in your documents equally, it becomes really hard to enforce anything at all, because you are creating defenses for the homeowners. If you go after one homeowner because they're not following this rule, they can bring up, well, you're not enforcing this one. Why are you picking on me? You're targeting me. You're being arbitrary. The board set precedent because they didn't enforce this over here, but now we're enforcing this. You can see how it can just kind of snowball. And also about the plantings. I mean, this comes up a lot. So we never get mad at owners that want to make their unit really pretty, and some do a really great job, and plant those annuals and perennials, and they're blooming and it looks really nice. But then what happens if that owner gets sick and has to go to hospice or a nursing home, and all of a sudden nobody's taking care of this stuff and it looks bad? If your documents don't allow you to fix it as a board or have some mechanism to control it, then you're stuck with things looking bad. So these are all the kinds of things you want to think about in advance, and be proactive about it. Next slide. Oh yes, virtual meetings, things that you want to change. Okay, so what happened in 2020? COVID, right? And all of a sudden we couldn't get together the way that we used to, but you still had to have association meetings and life had to go on, right? So many of us, all of us, started to figure out that we could meet virtually like we're doing today, right? We're doing this on Zoom. So, and that's great. And it works really well, but none of you had documents at the time that said virtual meetings were an option. They didn't talk about meeting by video conferencing. They didn't talk about electronic voting. And they probably didn't even talk about sending out packets by email, although you've been doing that for many years. So if your documents don't have these kinds of provisions in them, now is most certainly the time, if you haven't yet, to amend those bylaws to say these things. If you state it in your documents, then it becomes legal. It becomes a viable option for your association, and you avoid the problem of owners saying you're not doing it right, because they're probably right. It's also really nice when you're meeting by Zoom as an option for people that travel a lot in your association. They can still attend and be a part of the meeting. You want to make sure that you do have electronic voting incorporated into your language, though, if you're going to meet by a Zoom or a video conference, because in order to make it truly interactive, as if you are together in a room, you do want to be able to vote on the fly, right? And have people raise their hand, just like they might in a big conference hall together. And if you have the electronic voting language in your documents, you can absolutely do that. And you can completely take advantage of the ability to meet virtually and still do your business like you used to do it. Next slide. Ah, yes, insurance. Oof. Okay. So many declarations were written back in the day with insurance provisions that say things like this. The association has to insure the common elements, but unit owners insure their individual units. Or it might say something like the unit owners insure everything from the studs in. So their unit plus the studs, that's the owner's responsibility to insure. The association insures everything else. Or it might say something like the association insures everything except for unit owner improvements and upgrades, meaning the association will insure original construction, but anything more that the unit owner puts in their unit, it's the owner's responsibility. The problem with all of those things is that it conflicts with the Wisconsin statutes, which require that condominium associations insure everything, the land, all improvements on the land, that includes all the buildings, and that includes the units inside and the improvements in the units. So if you've got this kind of language I just described in your documents, wherever it happens to be, the declaration or the bylaws, this is a red flag, and it's something that you really need to take a look at as a board, as managers, and recommend that this gets to be amended very soon. The problem you have if you don't is that you may be creating gaps in your insurance coverage, because all association insurance companies, that their MO is to say, we cover what's in your documents. So if your documents don't match the law, all of a sudden you may end up with not enough insurance that you're supposed to have. And that means you have to pay money out of pocket, and nobody wants to do that. Everything I just mentioned was for condos because that's on the condo statute, but for HOAs as well, know that the kinds of insurance that you should have in your documents that the association obtains, you have to have property insurance, definitely liability coverage, definitely directors and officers liability coverage, because all of you guys are so well paid as board members. Not, you would definitely want to have insurance coverage so you don't have to pay out of pocket if somebody thinks you made a mistake. That's what D&O is for. And fidelity coverage, just in case somebody happens to run off with association money, you definitely want to have fidelity insurance there to cover you. So those are the types you need at a minimum. Next slide. Okay, so we're done with the big scary ones, but there are a few more yellow light type helpful amendments that you want to consider. If you're amending your documents anyway, we would throw these in there. Next slide. So if you're amending your declaration to do whatever you're doing, you might as well go ahead and remove all those references to the developer, to the declarant control period and expansion. Why? Because it's all over now. I mean, most likely the developer's been gone for years. It's irrelevant. It's confusing. I mean, as a homeowner, if you're trying to read through your documents and you get tripped up on declarant language and expanding the condo, it doesn't matter. It's just taking up space at this point. So those are things you definitely want to avoid and get rid of. It sometimes carries over into your bylaws because it'll talk about how the first board of directors should be elected when 25% of the units are sold and then 75%. I mean, it's stuff that's confusing and everybody gets strange about it. So you might as well just delete it. It's not important anymore and it will slim down that document packet just a little bit. You may want to consider adding alternative dispute resolution because, and we're talking about mediation, arbitration as alternatives when there's a dispute that arises between a homeowner and the association or vice versa sometimes, because who wants to go to court? Court takes time. Court is super expensive. Both sides have to pay attorneys for a long time to battle it out. Alternative dispute resolution gives you a much shorter path to a resolution. And if you write it into your documents, then you can avoid extended litigation, which can be really nice. And thanks to a relatively new statute in the Condominium Act, 703-245, if your documents don't address arbitration or mediation of claims, the statute does give a procedure that associations and owners now have to follow before filing a lawsuit. You do have to give a notice and try to work it out with a party before you go, which is great. I mean, I think that the intent behind this statute was particularly well taken. But it's kind of better if you as an association have your own rules on the matter, because then you'll know what the procedure is. Everybody can be ready in advance to follow it. And you can set your own parameters that way rather than just relying on the default rule by the statutes. So that's something to consider there as well. Next slide. Okay, other helpful document amendments, again, on the yellow light side. You want to certainly make your documents address your current situation as a community. Not only do the laws change, but the way your community is structured changes over the years. You've got owners moving in and out, your buildings are getting older, improvements in landscaping is aging, improving sometimes. So what you were given as a set of documents at the beginning probably does not exactly fit the way your association is operating today. So, you know, you look at it, you get rid of the developer language, and frankly, I mean, the goals of your developer, of course, are not matching what yours are today as homeowners trying to run the association. Developer just wanted to sell lots, sell homes, sell units, and get on his way. Wasn't really thinking about what a well-run association looks like because it's not their concern, but it is your concern as a continuing owner group. So by taking the opportunity to make your documents fit your association, you're going to be much better set to be set up for success as a board trying to run the show. Next slide. But wait, there's more. You didn't think we'd get away with not showing Billy Mays one more time. Next slide. So I know I threw a lot at you this afternoon about document amendments. So you may be just sitting there with your head spinning. There's so much. How do I even know what we're supposed to amend as an association? Well, we have a program for that. Since 2019, we put together a program called the Condominium Legal Document Review. If you haven't taken advantage of it for your association or haven't heard of it yet, this is my chance to tell you what it is. And then if you're interested, I'm putting the email of our paralegal, Sandra Chapman, at the bottom of the screen there. If you want any information about it following today's program, just shoot Sandy an email and she can send it to you. But what the program entails is basically just taking the guesswork out of what your documents need, allowing us to do a legal review, and we're going to give you kind of a scorecard when it comes down to it, as far as here's what the law says, and here's what your documents say, and how do they match up? Do you have a really good score so you don't have to do many amendments, or is your score pretty poor, but here's how we can fix it? And along with that scorecard, we provide recommendations on what you need to amend now, kind of the red light things like we talked about today, but also the yellow light, nice to have type amendments, and then also how much it will cost for us to do those amendments for you so that the board can plan and budget the way you want to and make an informed decision going forward on your document amendment process. It's a 3-year program, so the fee is spread over 3 years. And there are also a few more perks involved. So if you're interested in it, please do email Sandra Chapman and we will get you the information and you can go from there. And I think that's all we have. So if you want to go to the next slide, thank you all. Our next program, just because I'm probably going to forget to tell you after the Q&A, is July 20th at lunchtime again. So hopefully you'll join us and learn some more stuff. But at this point, I'm going to see if I can open up the chat. We will move to our Q&A, and if anybody has a question and want to speak, turn your camera on, or just shout out. You can throw on a raised hand, and we'll try to get around everybody that way too.
It does look like we have a few in the chat already, Lydia.
Super. Do you want to start with one?
I'll start with the. I have one here on short-term rentals. The question is, this isn't specific to short-term rentals specifically, but are there any recommendations on how to combat false listings on sites like Craigslist that are designed to scam potential renters by stealing the rental deposit? That's an interesting question. My gut tells me the short answer is no, because they're always going to think of a different way around this. There really isn't any involvement that the association can do other than actively monitoring for their properties being listed and perhaps alert that owner to that, so that they can then monitor for that if their property is being targeted as one of those listings on Craigslist. Yeah, as far as combating it, just report it on Craigslist, maybe report it to the police. But as far as what an association can do, I don't think there's really much that you could do, since it's not a party involved with the association doing it, assumedly.
Yeah. Okay, great. The next question I see there is on political signs. It says, can an association dictate where and when a political sign can be placed? And can they dictate the maximum sign size allowed? The answer to both of those questions is yes. The one thing I want to put a distinction out there on, though, because I don't think I mentioned this during my slide on this, there's a lot of different types of political signs. There's signs for social justice measures and things that have caused some associations some heartburn in the past. And what I want to make clear is what the statute is talking about is very narrow. The statute protects those signs that support an actual candidate for election. So it'll say this person or this person that's coming up soon, or a referendum question. So social justice signs don't get slotted into the mix. So if your association wants to ban those types of signs, you can do that. We get into free speech and all that stuff, but for the most part, associations have the ability to restrict exterior portions. So in the window, on the patio, anything that can be seen from the exterior, the association has a good measure of control. But for those political signs that support a candidate or a referendum, you can absolutely have rules that say no more than this many signs and the size and where they can be placed. If you think that they're appropriate in a unit's window, we can say that. And I like to add in rules when I'm drafting them some parameters around the timing, just because you don't want a sign for Ronald Reagan to still be up in 2024. It doesn't really make much sense. So by placing parameters on, you can place the sign so many days before the election, but you have to have it down so many days after. Helps to keep it reasonable and make sure that you don't have old signs hanging out there. So I hope that's helpful.
All right, one common one I'm seeing here is What is the appropriate amount to fine for the use of short-term rentals?
Mm,
Well, that's a tough one. Um, because it's ultimately going to be, again, you want it something to be that deters it, but you also don't want it to be something that's unreasonable. Um, again, I would say somewhere but more than $500, but less than $2,500 a month, maybe more. Um,
yeah, or maybe even per rental. I mean, I think you also have to look at like the market and what it's going for a night. So for the Republican National Convention, if prices go nuts, and they're demanding crazy prices, and you're only fining $500, the owner might just be like, sure, I'll just plan for that. I'll pay the association $500 a night. I'm still getting 2,500 or whatever it happens to be. So if you're planning in advance for this, I think it makes sense to pay attention to what the market is, what these units are going for, and then sort of crafting your fines that way to make sure they're not ridiculous, but then they're also reasonable, but they'll work to actually deter what you're trying to do. I see a question here about virtual meetings. It says, can you have virtual and email and electronic type rules in your rules and regs, or does it have to be in your bylaws? That's a really good question. For the most part, it should be in your bylaws only because there's already provisions in your bylaws about what a proper meeting is. So I think if we put them in the rules, we'll run the risk of conflicting with some of the provisions that are already in your bylaws. So most associations are looking to just update the bylaw provisions. If you're in a pinch and you needed to, pass a rule or something to kind of get you by because you're not going to be able to get that 67% affirmative vote that you need, we could look at trying to craft some language that would fit in with what your bylaws say. Might just take a little wordsmithing. But by and large, I would say the bylaws is the place to add those upgrades for sure.
all right, and back to short-term rentals. I see the question, are we able to fine immediately without notice of removal for listing on a website? If we are not able to, doesn't it become a cat and mouse game of list, remove, list again without penalty? And that kind of gets to the point of what I said earlier. When you're making it, well, the answer to your first question is it depends on what your rules say. And that's kind of what I mentioned earlier when I said, when you're addressing these in your rules, you also want to list the marketability of them, saying it's not just against the rule to actually rent it out, it's against the rule to list it. So when you're fining for listing it, it's easy to point to that, say that's clearly your house, that's your address, it's on Airbnb, we're fining you for listing it for the market of your unit as a short-term rental. And that's how you avoid the cat and mouse game of, well, I didn't rent it that night, it's just presented online as an offer, it's not actually renting it.
Mm-hmm. Yeah, that's a real good point. And I started crafting rules to say that that the listing of it on an Airbnb site or whatever is a violation, because on the flip side, it got a lot of people saying, wait, I wasn't renting that night. I let my cousin stay there. Prove it. And it's really difficult to prove that they're actually doing an Airbnb. You kind of have to piece things together. So by saying on both sides, just listing it for sale is going to be a violation of our no Airbnb rule, kind of gives you another easy way to prove that they're violating your rule. Gives you sort of both angles. Let's see if I can find another one. When amending to slim down the documents and remove language dealing with developer and declarant, do you suggest drafting an amendment and complete restatement rather than a simple amendment? I think if you just draft an amendment, you'd need to provide the original document being amended. And with a complete restatement, you'd be able to remove the requirement of providing the original. Yes, I absolutely agree. And I've been rewriting a lot of declarations over the past couple of years, and every time, if there's a lot of changes to be made, I've been recommending that we do a restated declaration as opposed to doing one more amendment that you're tacking on. So many condos were built in phases, and every phase was a new amendment. So I had some associations that already had 25 declaration amendments. So doing a 26 just seems nuts. But we do a restatement, and all of a sudden, all of those amendments and the original declaration become a historical document. And for your disclosure documents that you have to always keep up and provide to sellers when they're selling their unit, you just have one document now. You've got the restated declaration, that's your legal document. So that can be a really useful tool. So thank you for that comment. I completely agree.
All right, I have a question here. Can a member let one of their employees live in a condo saying they aren't, quote, renting it, yet that family living there is not paying rent? That's a tricky one. The short answer is it depends on what your documents say. As a practical matter, that one's going to be difficult to prove because they aren't renting in the sense that they're gaining any profit or commercial aspect to it. They're letting a guest stay there. Essentially, it's the guest of them. It happens to be their employee, but it's still a guest of the owner. And if they're, again, if they're not receiving rental income from it, does it really qualify as a rental?
Exactly. And that pinpoints the crux of the issue and how wording really does matter when you're doing these amendments. Because if you just write your amendment to say no leasing, well, an owner could get around it by saying, well, I don't have a lease with these people. I'm just letting them live there. And then that completely defeats the purpose. So oftentimes we want to speak in terms of owner occupancy and defining what owner occupancy means, as far as immediate family can be there without the owner, and that wouldn't be against the rule. Kind of putting tighter parameters on who is actually allowed to live there, as opposed to just saying no lease, because as we know, people come up with strange arrangements all the time to get around the rule. So the words really do matter in this case.
Got an out-of-state question here. What's the remedy in Missouri to amend declaration when half of the homes association units have converted to rentals, which the declaration allows, and the absentee owners resist any amendments? I'm going to recommend that you seek out a Missouri attorney on that one. Simply, the laws vary too greatly state to state to even really give you a solid way to start on that. Someone who's versed in the Missouri association's law could be more helpful in answering that particular question. So I just wanted to make that distinction there, just because we're presenting this is primarily with Wisconsin law in mind, and maybe a little overlap on federal. But for
yeah, good point. But I've seen that problem come up in Wisconsin. I mean, that's clearly an issue if you've got, already half of the association rented and you need more than half to change the rentals are okay rule. It can be hard. One thing that works with Wisconsin law, I'm not sure if it's going to work with Missouri, you'll have to check on it, but you could write the provision with a rental cap that kind of grandfathers in the current renters. So that might help you garner those votes of the people that are currently renting, knowing that you're protecting their right. But once they transfer their unit, that right to rent goes away. So the grandfathering kind of starts whittling down the number of units rented over time. Not perfect, but at least it gets you sort of on the path to where you need to be. That's worked with some associations here. So maybe in concept, if that works with the Missouri statutes, you could try that route. Let's see. Somebody asked if our PowerPoint's available for download today, and the answer is yes. At the very first thing, if you scroll all the way up to the top of the chat, is a link you can click on, and you can have the PDF of our slides. And also tomorrow, if you are a registered attendee, you'll get an email and you'll get a copy of this webinar recording for your viewing pleasure again and again, and also the slides too. So you can wait for that if you want.
All right. Okay, something just popped up here. Can you put listing and renting as Airbnbs in the rules and regulations as a quick way to address the problem and include the fines involved? Can that also include in the rules and regulations who is allowed to live there? As far as who's allowed to live there, that should be something that's typically addressed in a declaration as far as the use of the unit. And that also kind of gets to the point of rentals in general. If the rentals isn't addressed in the declaration or bylaws, it can't be something, or it shouldn't be something that you're making as a rule that's contrary to the declaration allowing it, or not allowing it. is if it is addressed specifically in the declaration or bylaws, and then you can create rules that do govern that in the rules and regulations, as far as manner, et cetera.
Yeah, good point. I'll also add, if your declaration or bylaws already has some rental restrictions, like say, it says that leases have to be at least 6 months, that could actually be helpful to you if you want to limit short-term rentals, because again, while best in the declaration or bylaws, if you're starting with that baseline, I think you can sort of improve on it in your rules and expand that, yeah, you can't lease for less than 6 months. By the way, that would be considered a short-term rental, and here's how we're defining it, and here's what's prohibited, and here's how we fine for violations. So as long as it doesn't contradict necessarily something that's in your declaration or bylaws, then you can certainly make some rules that tighten it up as far as STRs go.
Okay, it looks like we're getting a request to answer some of the insurance related questions. So I'll start with this.
Shout one out.
Does condo insurance include personal property? Where do you draw the line?
Condo insurance?
No,
no,
no, it wouldn't be personal property. It'd include everything but.
If the association owns some personal property, then sure, that would be insured by the association, but usually that's not the case. We're talking about an owner's property, the furniture, appliances, TVs, what have you. No, the association's insurance doesn't cover that. It's actually the only thing really the association's insurance shouldn't touch. Got any more insurance ones?
Trying to find another insurance one here. If the association is supposed to insure the interior of all units from the studs in, how does the association determine what the value is of the interior of all the units that have been significantly updated?
That is a great question, and that comes up a lot. So typically what we recommend is to get on board with what full replacement value really looks like, because that's what the association is required to cover. It is sort of a guessing game because this question hits right on target. Some unit owners are really upgrading their units and putting a lot of money into them, and some not so much. So how do you know what's the best kind of coverage? We recommend that you get an insurance appraisal every few years. I mean, some insurance companies offer to do it themselves, but you may want to actually look to get a third-party appraisal. What they'll do is they'll take a few units as kind of example units and take a look at what's in there and just sort of do law of averages, basically like insurance people do, and come up with the right number for your association. I think you can get a lot closer that way. And the board kind of knows what's going on. If you know an owner that has done a lot of upgrades, you'd probably want to point the insurance agent in that direction to take a look at that unit, or the appraisal, to make sure that that unit is part of what they're evaluating, to make sure you've got enough coverage there. But it's not perfect. That if there's any flaws in the system, I think that's probably the biggest one. But the appraisal can at least get you past that a little bit.
Okay, and unfortunately, that's all we have time for today. For those questions we didn't get to, we'll go ahead and answer after, and I believe an email is sent out containing those.
Yes.
Thank you all for joining us today. We hope the information was helpful to you and your organization. And closing housekeeping, as a reminder, this program is pending approval for CAM ICB credit and approval for legal education hours. We will send you an email tomorrow, which will contain a certificate of attendance, sign in for CLE and CAM ICB credit, a program survey, and a copy of the recording. This concludes our webinar. Thank you for attending.